So our keynote speaker is Charlie Merriman, who is a man who probably needs no introduction for most of you, but we're going to do it anyway. My piece about Charlie is that he always gives guidance and advice in a very professional manner, but in a light-hearted manner. I remember going to court as his expert witness appraiser, and he said, "We're going to have fun with this." And I'm like, "Okay, we will." So that's Charlie, for those of you who don't know him. Christy actually suggested him as our keynote speaker. I cannot take credit. It was brilliant. So she's going to give a little introduction as well. And Terry, if she has something to add.
So I really wanted it to be a roast, so I was trying to think of something. But the only thing I could think of is when Charlie worked for property valuation with us for a long time. I was a relatively new district advisor at that time. And I would say, "Charlie, I need a legal opinion on this," and I'd give him 2 paragraphs. And he'd say, "I need more information." I'd get so mad. "What do you mean you need? Just tell me the answer." And so now, 26 years later, I find myself saying, "But I need more information. I need more information." So I probably should have listened to Charlie, and I get it now that you need more information. And I want Terry to tell the Charlie story. Sorry, Charlie.
So I'm already turning red, right? So when Charlie first started at PBR, I started at the same time. So we're talking like 26 years ago now, or 25, or I don't know, something like that. Well, I had the biggest crush on him. Like, he'd come in the room and I'd be stupid crush on him. You know that kind? Well, I would say from that point on, I got over it, of course. Well, hey. When I talk to my husband or I talk to anybody that knows me, and I go, Charlie, they know exactly who I'm talking about. So yeah, that's my story with Charlie.
Okay, that's all I got. Charlie Merriman.
Jeez. I had no concern about doing this before. Now I'm all nervous. By the way, I had the same crush on you, so there you go. And I wasn't going to say this, but since you brought it up, I tell you, you are a friggin' great witness, and that was a great case that we had. And it gets to actually the very point of what I think of what I want to speak about in part. Yeah, I don't think so. But it's coming through, right? Yeah, it's coming through. Yeah, for those of you who don't know me, I feel a little bit like that Bob Dylan song, he was famous long ago for playing the electric violin on Desolation Row. I had this little stint with PB&R that was probably the most enjoyable, it was the most enjoyable job I ever had. It was a great group of people to work with, and it was just a terrific community. And it was also really fun because the legislature, sort of like it's done right now, changed the world with Act 60 and Act 68. And as the attorney who hired on Act 60, I always like to say I was the first one to have an opportunity to screw up the law, so that was really fun too. So let's see, what is the topic today is how to be an effective witness. And I think we need to talk about it both as assessors, professional assessors, and listers whose qualification is essentially their election and then their experience going forward. And in that context, the two fall into 2 different categories, really. The listers would be lay witnesses, typically, not always. They can definitely be called as expert witnesses, but then you want to have to qualify them as expert witnesses. And then, of course, the appraisers would be called as expert witnesses. And the difference between those is articulated in the rules of evidence, Rules 71 and 701 and 702, for Shuffle, 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 shuffle. Where's my paper? Well, that's okay. I'll just say it off the top of my head. Yes, Rule 71, which would be an opinion testimony by lay witnesses. So if you're a lister, can you testify? Of course you can testify. Do you need to testify? The answer is you probably technically need to testify because, as you all recall, the procedure is that the town has to first establish the validity of what they did. It's a short step, but you got to show as listers that you took a rational approach to reappraisal, to appraising a property. And once you've done that, then the burden shifts to the taxpayer to prove a different value. And so in that context, the listers, the only qualification to that is courts have sort of gotten away from that first step because it's so assumed. But still some courts require you to go through that first little step. And so if you're qualifying if you're testifying as a lister, you're probably going to at least have to do that. What about expert witnesses? What is an expert witness? An expert witness according to the rule is somebody who assists the trier of facts on areas of his or her expertise. And that really puts you in a position of being an ally of the court. You're not, although you are on one side of the table, you're not there to advocate on behalf of your town's position. You are there to assist the trier of fact in matters of your expertise, so he or she can come to terms with that. What does that practically mean? It practically means, and this is one of the reasons I said have some fun. They're on your side. The court is on your side. They want to hear from you. They want to know that you're not a BSer. They want to know that what you say is honest and that you show candor. So, of course, the first part of that is to know your facts. That's probably pretty obvious. Check the property carefully before you testify. But also be ready to admit if you don't know a fact. That kind of candor plays extremely well with the court. So if you don't know something, admit it. And also be willing to concede small points that are not critical to your valuation. I had a case once before, it was Randy Mulligan happened to be the assessor in this case, and it was a pretty straightforward case. It was before Judge Tour, who's a very smart and no BS judge. She's a little scary, I think, as an attorney before. She scared the hell out of me. But really good. And so we were up there with one of those typical cases where you have the property owner wants to fly spec your appraisal. Well, this is not 60% good. It's only X% good. This shouldn't be. You shouldn't put a 1.1 on the view. You know, the barn isn't worth this much. And by the way, that whole argument really is irrelevant to the issue at hand, unless the property owner is challenging the validity of your methodology, which the person can do. Unless they're challenging that, the question of the individual components doesn't get to the final issue. The final issue is what is the true value of the property, what's the fair market value of the property, and the burden is always on the taxpayer to establish that. So fly specking the replacement cost, new list depreciation approach to value, if that's what you do, doesn't win the person any kind of victory. At best, he may try to impeach the credibility of the listers by pointing out how silly this particular component is. Anyway, in Randy's case, the issue came up about a shed. What value does the shed owe to a $500,000 property? And Randy said, it's really immaterial. And the judge loved that. The judge just loved that. And so bear that in mind. Court's on your side. Speak to the court as though it were. And I think it'd be quite well. Let's see, what else did I want to go to? By the way, I'd love it if anybody has specific questions to bring them up. I'd love to make this a little more interactive.
Well, then I got a question.
No, not Tim. Yes, Ed.
So I was listening to part of a BCA hearing the other day, and the appellants came in and they said, you know, we don't have any problem with the value of this house. We just got a problem with the land value.
Yeah.
Can you just speak to that a little bit?
Yeah, it's perfect, isn't it? Because you know the answer. The answer is top gazook. I mean, it's the whole value. It's not the incremental value. What is that? Is that called summation approach? Yeah, which is, help me out and remember. Summation approach is an invalid methodology of attacking an assessment. And that would be something that you would want to point out to the court, or actually I think your attorney probably should, and maybe you could testify to it. The difficulty with it, as you probably know, it's a foreign concept to we lay people. The idea that, well, what do you mean? If you come up with a value lister by valuing various components, why isn't it valuable? Why isn't it legitimate to argue that some of those components are wrong and thus ought to be reduced? That's a very difficult concept to get across to a non-professional. So, you know, if you have that kind of argument and you're trying to educate the court or the BCA on that, the best advice I can use is to allow your attorney to let you explain that, because I think it's beyond most attorneys. Anyway. And also I wanted to mention, in the context of the court being on your side, one of the reasons the court is on your side is because both the law profession and the profession that you all are in share a commonality. It's kind of an age of enlightenment thing. Both the court and appraisers operate on the principle that an objective, unemotional, fact-based analysis leads to a more equitable, fair outcome in any kind of dispute. So you've got that same kind of rationality that the court has when you appear before it. And that's what you need to keep focused on, to remind yourself that you're on the same side as the court. Do not fall prey to getting emotional when property owners get emotional on their assessments, obviously. That's a place that immediately, right, yeah. Your Honor, that person is full of it. But, it immediately erodes your confidence, the court's competency. John?
Yes. Charlie, many years ago, right, Charlie?
Yes.
He always said, and I'm paraphrasing now, you always prepare for an appeal when you're actually appraising.
Oh.
That means you do your homework, because everyone might be an appeal.
I'm really
I've
glad.
never forgotten that.
No, that's a great point. I'd forgotten it.
You made
So
it.
thank you. Boy, I was smart back then. That also connects to something else. Always remember that your records are a public record, and they could appear before a court. So, act accordingly. Yes, you're absolutely right. Treat every issue, but another thing I wanted that is sort of tangentially related to what you just said is when you are testifying in court, be concise. Don't be like, be concise, and don't anticipate having to say what you already said again. All of us as humans fall prey to that, don't we? Thinking that what I said you didn't get, so I'll say it again. Do you understand what I mean? Let me say it again. So, right. So don't fall into that trap. And be confident. I'll tell you, there's nobody who asks, what do you mean by that? Quite with the same whine as an attorney or a judge. So be confident that if they didn't get what you were saying, either your attorney or the other side or the judge, they will ask you about it. Any other issues? Okay. I had a couple of questions here that came over the internet about what mistakes can be avoided going into trial. I think we've sort of talked about that. Prepping with your attorneys. Does anybody have a live case right now before a court or a state appraiser? It's sort of a dead area right now, dead time, I should say. But you should definitely do some dry runs with your attorney before you appear. I have some hope that most of the appeals going forward are going to be by Zoom. They were, of course, during COVID, and it worked really well. Didn't you feel like that case was, it's a great savings for both sides to do it by Zoom as opposed to in person. You save the attorneys and the witness fees of traveling. And it seems to be a very efficient way to do it. So I like it. I hope that we're going to get into that some more. There's all the obvious points. If you're going to do it by Zoom, you'll want to do it. Make sure you have a pair of pants on. Can you problem? There's also a question about the appeals before a judge versus before the state appraisers. Do any of you have an inclination where you would rather be, or what would drive you to want to be before a state appraiser versus a court? No thoughts on that? You like state appraisers better? And why?
Judges don't know enough.
Birds of a feather,
Yeah,
right? Right.
They don't want to deal with the real estate. They have other things to do.
The courts?
Yeah.
Well, you may be right on that. I mean, the bench is wide and deep, and there's a lot of different judges, but some judges love it, because some judges are bored out of their gourd. I mean, they get up there and they hear another eviction case, and another case of this, it's appraising is interesting for the layperson. Most people have bought a house or sold a house, so that makes us all feel like we know what we're talking about. And judges are the same way. And now suddenly you have this issue before them about, and it's also fun because you get to see, if it's a high-end house, you get to see what the high-end house looks like, and who doesn't look like looking at Zillow. So the courts enjoy it. My preference is for the court over the state appraiser, only because it's more of a known for me. And also, although the state appraisers have become excellent at understanding procedure and the elements of law that are important to them, it's still, they're lay people in that, and the court isn't, and I feel like I get a little bit of a better hearing before a judge than I do before a state appraiser.
I think it's more control, John.
Oh, yeah.
Control.
That's a good point, too. Yeah, that's a very good point. It can go a little off the rails with a state appraiser at times. Yeah. You're not a state appraiser yet? Why aren't you a state appraiser yet? Let's see. I wanted to talk just briefly about what I think. How am I doing time? Good. Briefly on your favorite Act 480. There's a piece in there that it's poorly placed for lawmakers. You'd think they'd be able to write a bit better than this. But, oh gee, is that snarky? A little snarky. In the middle of a discussion on reappraisal and burdening PB&R with doing a lot of work for only $50,000, they asked the department to determine whether there should be a narrowing or eliminating the roles of boards of civil authority with the appraisal appeal process. I don't know where that came from, and I don't know if that's a good idea or a bad idea. I've always felt it would be a really good idea to follow the route of New Hampshire, which instead of having individual appraisers, has what we used to have in Vermont a long time ago, which is a board of appraisers. Yes. I think it's much better.
Yes.
But to get rid of the BCA, I don't like that. No. I don't like it for the same reason I don't like the slow erosion of listers. Part of what Joe and I were just talking about was you do need a local face on this issue. But even prudentially speaking, imagine if we get rid of the BCA, how many more appeals will be going to court, and how many more appeals will be going to, If there's too much process in the system right now. Grievance to BCA to state appraiser to Supreme Court. So I can see making it a little more rational. Getting rid of the BCA is, I don't think, a good idea. So that might be somewhere where you folks ought to weigh in heavily. with the legislation. Is that my time? No? Oh, Christ. Where's he does? He knows. He knows. Okay. Any other questions? Yes.
I have two actually, but let's start with the first one. A lot of people are confused about. It comes up in court cases all the time when listers are going to court and they've heard that, well, we have the presumption of validity, so the taxpayer has to burst that bubble. And through the court cases that I did with you, I got an education of that. So could you maybe explain presumption of validity and
Sure.
bursting that bubble versus burden of persuasion?
Love to. That's easy. Yes. Yeah, first of all, there is a presumption that applies to governmental activity in general. So this is not just unique to listers. It just happens to be very clearly articulated. The notion is that we government people do what we're supposed to do. The presumption of validity says that there's a presumption that what the listers did was rational. It was rational. And to show that, the court often asks the listers to describe what they did. What do we do? Well, we developed a land schedule off of sales where we graded various components of it. Courts know about that because there's wonderful case law about it. And then we applied replacement costs plus new depreciation. That's how we did it. We use a CAMA program. That's it. You sit down, you've established the presumption of validity. The taxpayer now has the duty to burst that bubble of validity by bringing forward some evidence of a different value. And it's not a hard thing for the taxpayer to do. It's a simple thing for a taxpayer to do. But it's more than, I think my property is worthless. They have to have worth less than that. The property owner has to come forward with some evidence in support of a different value. Once that's done, it's not an even fight even after that. The burden of persuasion always lies with the taxpayer. If they cannot show that the value that they are trying to forward is the true value, then you win, irrespective of how many times they point out that that shed isn't worth $1,000, it's only worth $400. This case actually came out really nicely in a Hubbardton, I think it was. Yeah, Hubbardton case. Very smart guy. Tried to develop an argument that the valuation around the lake was wrong. And he came up with a very good theory of a different approach for valuing the property. And that's sort of what the court said. Well, this is interesting, but it doesn't prove your point. You lose. So, yeah. Any other questions? All right, well, I sit down, Don.
Here's
I
one.
got a harder one.
Gotcha, good, it'll be a harder one.
And we got a couple back there.
All right.
Oh, yeah, no, I don't think we're gonna let you go that quickly.
One thing I wanted to tell you, I retired. Wait, I want to hear your question, but right now I just want to throw one thing out. I retired recently. And yeah, so.
You did?
I did, yeah, I'm very retired. But
I'm
anyway,
still working, you should be.
well, you're a lot younger than I am.
Oh, geez, yes.
Anyway, I miss all this, and I'm happy to talk to anybody if they want to. If they want, I'm not allowed to act as an attorney anymore because I gave up my license, but I certainly am allowed to have views. And if anybody wants to call me at 249-8096 on a particular issue, or just to see if I'm,
I got that in my
Bored.
phone.
Yeah. No, I'm delighted to talk about stuff. I find this good. So if you have a question coming up on a particular appeal or something, I'm delighted to. Except for Walter and Jeff, those guys always call. And their questions are too hard for me to answer. I'm sorry. Yes.
So this is one I haven't ever dealt with. I have a taxpayer who went through the three-tiered process.
Yes.
Got a decision from property valuation and review, and now is going to the Supreme Court. And we've always been told that, and the hearing officers say this at every PVR hearing, that any appeal beyond PVR or court is only on legal and procedural matters. It's not a retrying of the value. But I am guessing that it kind of ends up being a retrial of the value, so I want to know how that works, and other than hiring a really good attorney, and I'm so bummed that you are retired.
That's very nice.
How do
of
we
you.
handle this?
Well, okay, so you are right. An appeal past the state appraiser or the court is on the record. Everything else is de novo, which of course means new. So you have the grievance, it goes to the BCA, it's all new facts can come forward in your arguments of either side. You go to the state appraiser or you go to the court, same thing. You can come up with a whole different set of facts and arguments. Once you're at the Supreme Court, you're locked into whatever the facts were at the trial court. I don't really think that, no, I'm confident that the Supreme Court goes only by the record below. And the question becomes for the court is twofold. One, did the trial court err on the facts, or did it err on the law? On the law, the Supreme Court says, we're the bosses, we know, and we don't defer to the trial court at all. If they misapplied the law, we'll address that. On a factual issue, the standard is extremely high. To reverse on factual issues, you've got to show that the trial court, that they made a fundamental error. So you have to show that their fundamental error is not just a question of opinion. And it's very rare that a decision will be reversed, at least from a trial court on that. From appraisers, they're probably they scrutinize a little more carefully than they do from the courts, quite frankly. Does that respond to your question or not?
I still wish I could get the town to hire you, but yeah.
Well, thanks. Anything else? Yes, ma'am.
Is there any magic wisdom for when a taxpayer says, why is my 2 acres of land more valuable than this person next door, 3 acres of land? Is there some...
That's more your question than mine, but I mean, yes, obviously perking and view and blah, blah, blah. But
Yeah.
also one thing you can say is, I don't think you should, but I mean, you know, the fallacy in that argument always is that it presupposes that the other person's number is wrong and can be used to determine your value. It doesn't make any sense. It's possible that you're undervaluing that property as that you're overvaluing the complainant's property. So it's sort of it's a garbage in, garbage out argument. Not to say that your value is garbage, but they can't rely on that. They're basically saying you used a methodology and came up with a value here. You used the same methodology and came up with this value for my property. What's wrong? Well,
Okay,
yeah.
thank
What? You're laughing because you think I'm dying up here. I'm not dying up here. It was all day.